have you communicated with a social media user who goes by the name ThatUmbrellaGuy?
I've had several phone calls with the person who goes by the name ThatUmbrellaGuy. I don't actually know his real name.
I'm calling from Los Angeles, and I'm having a little problem under the name ThatUmbrellaGuy. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me, or I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me, or I'm a man.
I deleted my heart, and I really want it back. I don't want to feel like I might be a sociopath. I deleted my heart. I was young and impulsive, and I would download another, but I'm afraid it wouldn't fit. I deleted my heart. 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 I deleted my heart.
Hey, we love that umbrella guy. All right. Thank you. Under my umbrella.
When I was young, it seemed that All right, that was funny. Forgot to add myself to the stream, baby. Woo! Starting off Monday with a bang. How's it going? Sorry it took me a minute to get in here. By the way, yeah, our front door we have we have a stained glass piece in the door. You know, it's an older thing, and it fell out. The whole freaking front door piece fell out. So we have to tape it up, and I guess we'll have to get a new door because we can't get the thing back. The little things that hold it in are broken. I was like, no, no. But that slowed me down a little bit today. Whatever, it's like right before live streams. It's like the everything in the house knows. It knows, and it's like, oh, you ain't doing that, son. You ain't gonna do that on time. What's up, Fallen Hero, by the way? Thank you for the gifted membership and starting out the week there, too. Thank you for that. Also, let's see. Julia, thanks for the vibe. Just want to mention love for the real Laura B. Indeed. Real Laura B. Always loved real Laura B. Good people. Not just good people, but, really is let a lot of people know about everything that's going on. So she probably is the go-to source for this case. If you ever wanted to know anything on it, she was the source for so much information. So I do have to give her love for sure. Indeed. So thank you. I think that was a good mention there. Also, what's up, Lynn? Thanks for the 12 months. A whole year with the tug. I know. Happy anniversary. Thank you. And Eric, thanks for the 9 months. Whoa, way, you had a baby umbrella. We love that umbrella guy. That, by the way, funny enough, that clip at the beginning of it, that was from Anime Matsuri. That was years ago. So I'd be curious. I haven't done a live event in a long time. Like I haven't been at a place in quite a long time. When I was there, I had a mask on. If you go and watch the panel from it, I was wearing a Jason type hockey mask the whole time. So it was something to check out. Now we're going to go over Nate the lawyer, over the dismissal. If you haven't heard about that, yes, his lawsuit was dismissed. I'm going to read the decision on that because we should go over the decision. And I want to read what Nate had to say about it too. It's crazy though, because the judge is a really piece of work. Basically, anybody can ruin your life, and here's a lesson, people, Kitchen Chris has been patting himself on the back. He doesn't realize that basically the standard that's set with that is anybody can accuse his ass of anything too. The problem is that he has real skeletons in his closet, But we'll go over that dismissal, and it's nuts. It is absolutely nuts. What's up, DJD? Thanks for being back. The good night. 8 hours left. 500 to go. Yeah. Somebody link that. Actually, DJD, can you link that? Yeah, link it in there. The good night, the comic book, definitely back that. It only has a few hours to go. It's a good project. First one was really good. And Sandy, thank you for the hey there, by the way. What's up, Ninja? Thanks for 5. I stand with Nate the lawyer. As a fellow disabled person, I have a genetic condition called, I don't know how to pronounce that. I'm terrible there. I have 23 operations. I hope you're doing okay now. I don't know how that affects people exactly, But yeah, actually, I just stand with, I think Kitchen Chris exposed himself in so many ways because he went after Nate the lawyer with some of the most racist, vitriolic statements ever. And his crowd, the tolerant crowd is there, supposedly, the ones that don't believe in harassment and disparagement, they love to scream about ableism and on. They're the first through the door saying the most hateful things possible. But Nate the lawyer here, he put up a statement with this. And he said, hi, everyone. I wanted to let everyone know what has happened. The case was dismissed. I'm going to read you the decision on that too. We are allowed to refile. It has been 6 months, and finally we know the outcome. Essentially, the judge concluded, and again, we'll read this, even though Bouzy's claims were false, we didn't have enough to show actual malice. Now, I wonder here, one thing I didn't see in their evidence, and I pushed, I was like, yo, you need to add this. Kitchen Chris went out of his way to hide anyone. Okay, on the statements where he tried to defame and destroy Nate the lawyer, he purposefully went out of his way to hide any statement that corrected the narrative. That's not him being misled. That's him hiding the information. I was like, that needs to be, it's archived, it's archivable. And it showcases, again, everything that he hid. I, for the life of me, did not understand why that was not put in there, because I believe that that would help show malice. You know, again, maybe I'm not looking at that right, but I would have thought that that would help. You know, when he's going out, actually trying to damage, you know, not being misled. He went out of his way. He edited a video in such a way that it gave a false narrative. He made sure to post said false narrative, and he hid anything that tried to correct said false narrative. I mean, it seems like the circle of life is complete. Yeah, but it's just me. And again, I mean, it seems like it. But again, you get some judges that are just, you know, and all lawsuits are crapshoot. I think you've learned that by now. You know, Amy, thanks for the 10 months. Much love to you, your family. Hope you're well. Thank you. Much love from Belfast. What's up, Northern Ireland, UK? Well, thank you for that. I appreciate that. Much love returned from Tennessee here, for sure. You know, when I say that too, you can, again, it's all a roll of the dice. But the decision, we'll read through it again. And anyway, let me finish this. So we had to show that Bouzy knew what he said was false, but said them anyway. That's how you do it. My God. How you do it. He hid the shit. That's what I kept saying, man. I archived it. I sent it to people. I'm screaming to the walls and no one's listening. For real, though. I mean, it shows that it wasn't because he was the source of the lie. And with him, again, I mean, he created a custom tailored, ready-made narrative that only he was producing. I mean, it's like I said, it seems cut and dry there. But again, and that's not aimed at any of the law. I'm like, there's so many. It's easy to backseat drive fucking something. You know what I mean? They made a lot of good points. It got a lot of attention. It got Wired ended up exposing Kitchen Chris as an old crypto scammer. Of course, the real joke is, in the time that we've watched this lawsuit come up, we've watched Bot Sentinel die. We've watched Spoutable turn to dust. I mean, Kitchen Chris, he's setting, you want me to tell you the funniest thing? He's setting right now on Twitter trying to do a victory lap. And I'm like, you don't really get the meta to that, do you, dumbass? I mean, if Spoutable actually worked, you'd be doing your victory lap there. But nobody cares because you're just screaming to the nothing. But an example, when Bouzy claimed that it was not a lawyer, this statement alone was not enough to sue for defamation. We believe that when Bouzy later claimed that he knew I was a lawyer, when he claimed it was not, that would show actual malice. Again, the court stated, and we'll read this. Okay. I think they should go back in and add what I just talked about, just straight up. Again, a lawyer can set me straight if I'm wrong on that, but I believe that needs to be added. If they disagree, they disagree. That's their thing. That's their prerogative. But I think that again, you add in enough stuff to try to make that point there. And this is the decision. So before the judge, you can see, the motion to dismiss, blah, 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 background. Plaintiff, factual allegation. Plaintiff As a former university police officer of the city of New York, a member of the New York Bar, and a former Bronx County assistant district attorney, and former law school instructor who creates and operates a YouTube channel under the name Nate the Lawyer. Defendant is the chief executive officer of Bot Sentinel, Inc., a New Jersey corporation that purports to fight disinformation and harassment on Twitter. Plaintiff is a resident of New York, and defendant is a resident of New Jersey. Plaintiff's YouTube channel, which is founded in 2014, has approximately 255,000. By the way, props to Nate for 250,000 subscribers. Let me just give him some love there. And has attracted millions of views. Yeah, more than that, actually. Nate's attracted a lot more than that. But it publishes pre-recorded videos as well as quote-unquote live streams in which viewers watch a video program in real life with the option to participate in a running stream of commentary that is visible to all participants in a chat window shown next to the video. Viewers can pay to have their chat comments rise to the top of the chat window or stay pinned. You know how that works. I don't need to read all of that shit to you. You know? I don't really need to read that part. Plaintiff is part of an informal group of experienced lawyers with law-oriented YouTube channels referred to as LawTube, who live stream legal commentary and discussion, often appearing on one channel as a group. Among other content, LawTube hosts have live streamed sensational trials that were video recorded for public viewing, including the criminal trial of Kyle Rittenhouse and the defamation trial between formerly married celebrities Johnny Depp and Amber Heard. The popularity and revenue generated by these live streams depends in large part on how potential viewers perceive the host's experience, professional knowledge, and above all, credibility. Bot Sentinel, which defendant founded in 2018. RIP, by the way, Bot Sentinel. Chris is out there like, Bot Sentinel still works. And it's like, no, it doesn't, dude. It is a giant e-dumpster. It is it is. It's basically where old data went to die. I mean, there's nothing else there. Oh, it's pretty funny. No, it's going to come back. I'm like, how's it going to come back? What are you going to do? You could just make up some stuff. I mean, you made it up before. I guess that would work, but shit, you know. Kitchen Chris doesn't understand this, by the way, while I'm reading this. Kitchen Chris doesn't get the fact that sooner or later, the mob that he caters to, they will turn on him. They already have in a lot of ways. I mean, you had Cat Tinbarge and others. They turn on, and again, it was his fault, but still, they do turn on each other. They turn on each other very publicly. They eat one another. They're like, they're like the buzzwording version of Twitter Pac-Man, you know? They're just like wonk, wonk, wonk. They eat each other like so many power pellets. And it's fun to watch. But Chris doesn't get the idea that Chris is an absolute asshole. And people don't like Chris. I don't even think sometimes Chris likes Chris, just to be honest. And he's made a lot of high-powered, high-profile enemies. Even a lot of the people that he's friendly with, I would call them frenemies because he's definitely not got friends there. But anyway, he describes himself as a nonpartisan platform developed to classify and track inauthentic accounts and toxic trolls on Twitter to fight disinformation and targeted harassment on that platform. Now, again, how do you track? You know, he's already started saying, well, we're not designed to track bots. We track inauthentic account. What does that mean? What does that mean if it's not a bot? What exactly are you talking about? You talking about people that you don't agree with their narratives? Are you admitting that you're just a disingenuous fucking political and social shill? A paid bully for hire? Is that what you're admitting? Because you can't track bots. That's what you said. So inauthentic accounts. Oh, they're not authentic. They're not real enough. Why? Because they don't agree with you. Anyway, it reviews Twitter accounts it considers suspicious, including both automated. Wait a minute. Isn't that a bot account? Again, Chris admitted he doesn't track bots, but they review automated accounts. What the fuck? I swear, man, he really should call himself Kitchen Chris. You know why? Because he serves up a mean plate of word salad. I mean, really, what are you talking about here? That's not a bot. That's an automated account. This word salad is delicious. It's like, are you fucking kidding me? I can't have any French dressing on it, though, because bot Sentinel can't speak other languages. Anyway, known as bots. Oh, wait, it called them intro bots. It did say that it tracks bots. A lying piece of shit. He's out here telling the world press that he can't track my. You know what irritates me? Wired. Get off your fucking hands and really report this stuff. Come on, dude. I mean, you went out. These people are so scared somebody like Kitchen Chris is going to come out. Who cares, man? I mean, what's he going to do? Again, he's going to scream to the echo chamber, and it is an echo chamber, both in politics and the fact that it's empty. Scream into the void. But it's also screaming to the void that are the people that are there. Anyway. Gay, what's up, Geekadelic? I like that name, by the way. Thanks for the tip. Bouzy, a toxic troll. Tracking toxic trolls. Irony. Indeed. Troll bots. It's a troll bot. It sounds like a bad Transformer, doesn't it? Optimus Prime, he's going to roll out as a tractor trailer. Oh, look, it's Prowl. He's a car. Oh, look, it's Kitchen Chris. He's the shape of a troll bot. He's going to control it all from his headquarters in the kitchen. Oh, look. That'd make a cool toy, wouldn't it? You'd be like, oh, with working microwave sounds. He's like, I'm going to get him now. And he turns all the little dials on his kitchen. He turns his stove. He's like, that'd be awesome. I need a Kitchen Chris toy. That'd be really funny. Oh, one of you amazing. If you made one of those, that would be the craziest thing ever. I would live stream playing with it. Oh my God, that'd be great. Anyway, sorry. I'm very distractible. I am very distractible, which it defines as accounts that exhibit toxic troll-like behavior, such as retweeting propaganda and fake news or engaging in repetitive bot-like activity. Again, it's like pot meet Chris. Chris. I mean, serious. I mean, what are we talking about here? Someone that regurgitates fake news or propaganda. That dude is a propagandist, man. He is a fucking talking head propagandist. Bully for hire. Straight up. There's Wired reported that. Wired reported the propagandist stuff, and it better because, of course, they agree with the politics, But yeah, I mean, when you're out there regurgitating like Rolling Stone and Taylor Loren, you're a fucking propagandist. Embrace it. It then rates these accounts in a publicly available database as either normal, satisfactory, disruptive, or the biggest buzzword out there. You can tell this fucker is a buzzword because the worst word that you can get beyond disruptive is problematic. Dun, dun, dun. Problematic. And then tracks their activities daily. Not anymore, baby. Bot Sentinel solicits donations on its website and has been played by clients, including Meghan Markle. Pete Buttigieg. I don't even know how to pronounce this, what I mean. I would call him Pete B, because I don't know who he is. I shouldn't be rude about his name. I don't know how to pronounce that for real. And of course, Scamber Heard. Between July 2020 and July 2022, newspaper articles cited Bot Sentinel's research. I swear. Hey, look. Hey, my kids out there. We're making Bot Sentinel 2.0, My 3-year-old's coming up with her data right now. Like, hey, baby, like this account right here, how would you rate it? Yeah. She's like, pizza. I'm like, yeah, pizza. I need to call her 4-year-old, by the way. I got to get that in the habit. We call her 3 so long. How do you rate this one? Flowers. Yay, flowers. That one's like, wait, how do we? What's this one? Poop. Okay, that's it. We'll call that. Anyway, research in reporting numerous Twitter accounts has been created specifically to target Heard and her supporters. Twitter accounts with hateful comments and threats. It's like listening to Charlie Brown's teacher, you know, when you hear it. After a while, these people just sound the same. Like, I created that. Oh, took money from to report on those that quote unquote target. Huh? Do you see a problem, baby? See, there's the thing. Like, all of this stuff ended up in the public sphere. Now, many assholes will just put their fingers in their ears right now and they go, la, 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 and they won't listen. But they do listen because Kitchen Chris has a meltdown every week. Every stinking week, he turns on somebody. Last week before, he banned a guy with I can't remember if he had a disability or if he had mental. I keep thinking he was on the spectrum, not he had a spectrum diagnosis. He didn't have a physical disability per se, but I can't remember totally. But he targeted that, and then another guy with like 80,000 freaking followers asked, "Hey, Bot Sentinel, is it this or that?" And Chris went off on him for asking a question about, hey, Bot Sentinel is a toxic place. That's when people return to this stuff and they see it. And that's the beauty of this. It's basically the paid report. He can spin it. And most jackasses won't read this. That's the problem. Most of the jackasses, they're just like, oh, Chris, you're the greatest. But sooner or later, when he turns on them, they'll go back and look. I've seen that happen many a time. Heard paid Bot Sentinel for a report that found she was subjected to one of the worst cases of cyberbullying in a trial, as stated in July 2022. Newspaper headline. Could you imagine paying? By the way, what do you think his results would have been when you pay it? No, nothing happened. Of course not. How are you going to get those people to come back in? Oh, my God. You know why? Because he... Oh, did you hear the wind whistle? Oh, yeah, I heard that. Oh, my God. You know what? The wind needs to stop whistling. Why? Because that's harassment. It's catcall. Oh, no. I think I heard it say something racist. The wind is racist. You know why? Because it's clear. What does that even mean, Chris? Oh, shit. In September 2022, defendant and Bot Sentinel turned their attention to plaintiff and other LawTubers who had streamed the Depp Heard trial. Actually, he did this before then. This is the factual inaccuracy here. I get for the point of a narrative there. Kitchen Chris was aiming at many of us with that report right there. He aimed at us before the trial, well before the trial. When he got paid early on, he had been trying to take folks like myself. He tried to take me out several times. In fact, if you look through that, one of the things I can think, Ian, that's one reason I like the quote unquote LawTube, because they stood the ground. They were like, this is bullshit, because he put out this nasty hit piece report. I am obviously not a lawyer, but I play one on you. No, I don't actually. I just like trials. Again, if you want law breakdown, there's plenty of lawyers. I have mental health background. I look at these people and be like, man, that's a diagnosable mofo right there. Now, I won't say what diagnose, but when you look at that, it does add an element. I always look at some of these folks and I think, what would I diagnose this person with if they came in? Because you can't help it sometimes. You're not supposed to do that, but you can't just turn that off, What's up, Fallen Hero? Thanks for 8 months, man. Hey, Tug. Hey, how's it going, man? So In September 22, he starts going after the LawTubers despite their diverse political views and backgrounds. That's very true, by the way. I mean, if you look at it, see, this is what kills me. You want to destroy the narrative of everybody's right-wing monsters. Ian Runkle, he's a complex person. I enjoy it. We would disagree on some stuff. We did agree. That's healthy. Nate, again, we're not talking about like some, conservative or right wing, whatever you want to call it. Myself, like I've said many times, I can't stand any of it. I'm a burn it all down kind of man, So yeah. But the whole narrative, that's true. That's very true. Diverse political views, backgrounds, again, people coming from every background. That's the beauty of it. Dreadnought, 35 months. Thanks, brother. Trobots, lie more than the other guy. Trobot grifters in disguise. Ultimus form, Spoutimus Prime. Spoutimus. Hey, 1 second. Give me 1 minute. All right, sorry about that. We're talking about the front door where the glass fell out of it. Like I said, my daughter, yeah, it's old door. It's got a piece of, like I said, stained glass, big old piece of stained glass inside of it. Fat. My daughter went to close the door, and the whole thing came out. She's like, "Oh my God, I broke the door!" But no, the little pieces that hold the door frame together, they cracked inside of it. And there was no way to fix them. It's like, it wasn't her fault. It just, things happen over time. But that's what we're talking about. Anyway, so the LawTubers, despite all of that, were virtually unanimous in their opinion that Heard was not credible in defense against Depp's defamation claims. Interestingly, many of the LawTubers thought that Depp would lose at first. You know why? Here's the thing. And again, this is not meant with any ego. You know why I knew that Johnny Depp would win? Because they read the law. But you know who had it right? DUI guy. He read the people involved. See, when the people get on the stand, that's what the jury looks at evidence and they read the people. And in reading the people, I've seen Heard, and many of you had too. That's how. It's pretty sure. Now, again, there's no certainty there, but I was pretty damn sure because I'd seen Heard, and I knew that she would try to overact. I knew it because there's no way from those 2016 videos that she gotten any better at it. She seemed more, when she was young, she seemed more just straight up asinine. Now she seemed like a terrible actress, and the asinine part would come out, like the defensive, eye rolling, attacking and stuff. I mean, it would come out. But when you're reading the law to it, that definitely, it is a major part. But the people sometimes are this huge counterweight. And many of them had never seen Heard before. They'd never seen her in action. So when they started out, it's like, yeah, no, he's going to win. He's going to win because everyone's going to see this, and he's very good at getting his point across. I had read a few of these witnesses, but I couldn't believe how bad they were. They sounded terrible on paper, some of these folks, but I was shocked by how bad some of those witnesses were for her. And I'm not talking about like the co-conspirators. I'm talking about the experts. I mean, what a bunch of idiots. Anyway, continue. Some LawTubers, including plaintiff, had also expressed views critical of Bot Sentinel's claims of widespread coordinated attacks on her social media. Yes, that's true. Again, what really focused him on Nate is that chain of events. Again, they wrote up the thing on, it was supposed to be, Meghan calling out people that they considered attacking Meghan Markle, and right in the middle of it was me. And again, they put in those crazy quotes that would have 6 hours between some of the sentences. And Ian Runkle called it out, and Law and Lumber. And again, I'll forget everybody, but everybody. But Nate, you know why Nate got targeted? I'll tell you, because Nate's black. That's why. Chris made it very clear. He targeted him because he was black. He called him a token and many, many worse things. They targeted him for disability and everything else, but he made it clear he went after him not because he disagreed, but because he felt he could get away, and he did. Again, because the tolerant among us, they are so tolerant, right? Through his personal Twitter, defendant demanded that YouTube delete some of the lawmakers' accounts for troll-like behavior he deemed inappropriate, including spreading propaganda and fake news. On or before September 19, 2022, Botseno rated plaintiff's Twitter account as disruptive. September 17, 2022, defendant posted a number of tweets about plaintiffs, some of which he later deleted, in which he questioned plaintiff's credentials. Question them. Is that what that is? For example, he stated that he could not tell if the plaintiff was a legit lawyer or just a social media lawyer, and that he could not find plaintiff in the database where he claims he practiced law or find the news articles that plaintiff claims to be featured in. He tweeted that there is no history of plaintiff practicing anywhere. Maybe the name plaintiff is using isn't his real name. I remember that. That was so funny. What an idiot. The following day, defendant conceded that plaintiff was a lawyer and shared records of plaintiff's status as a New York attorney. He also admitted that when he made an earlier claim, not being able to find any record of plaintiff practicing law, he already had the information, but was waiting on someone else to tweet it so he'd not be accused of inappropriately sharing plaintiff's real name on social media. That's the double talk of Bouzy. I actually knew he was. Really? Because you made an idiot of yourself, and now you're making more of an idiot of yourself? Good job, Kitchen Chris. Good job. I mean, again, when you look at this stuff, like Kitchen Chris doesn't deny this. Here's the thing. So, this put on record what kind of an asshole this guy is. And beyond that, being an asshole online, that's nothing. That's like, saying that my grass is green. I mean, of course, there are many. I can be one. But he goes beyond that. Again, it goes well beyond that. And again, the crowd that he rolls in, they are supposed to be above the fray. Like people like myself get accused of making fun of people's beauty standards, which I really don't. Unless if somebody came at me, I got some flack one time because somebody did everything they could in their power to try to ruin my life. And I called them, brace yourself, I called them fat. I was like, oh my God, he's an ableist piece of shit. I was like, are you kidding me? Are you fucking kidding me? But no, I mean, who cares? Who cares? It's amazing. Again, they're supposed they have words like ableism. They have all these titles that they love to roll around. They buzzword off the tongue, but they're meaningless. So anyway, he called plaintiff a grifter, a professional liar, and suggested that plaintiff use donations from his followers for this legal action to make himself and his lawyer richer. He accused plaintiff and others of starting a coordinated smear campaign against Botseno. Oh, yeah, man. It's a smear campaign. Oh, you mean the place that says it tracks bots and can't? The place that rates some of the worst accounts on the social media, some that actually tweet out some of the most racist shit you'll see online, or some of them that tweet out like Yahtzee material. Yeah, they're ranking scores for some of the worst places. And Nate actually showed this before. There's some of the worst places line. You can track them down, and they are scored perfectly for Botseno because it doesn't track off of that. It tracks off of hashtags. And hashtags, there's no they assign a weight or a score to things that they are paid. They either are paid to stand against, or they find they help them politically or socially grift more. That's why a hashtag that is it is debt positive, or it is not anti. It isn't. I wouldn't say anti, but it is Amber Heard centric, but not in the way that they would like. Yeah, that's why they get hit, and Markle and everything else. Again, monies. So on September 21st, plaintiff through counsel transmitted a letter to defendant demanding the whoops, I missed a part here. The video. I missed this part. The most serious, rather. September 2021st. Defendant posted a series of tweets stating that plaintiff had admitted in a video he planted evidence as a cop and knew when the cops bought subjects in with bogus evidence when he was an ADA. This right here, like I said, what's not here and not mentioned, he hid the stuff that came up. He has to manually do that. Like, I've never hidden tweets. I've never hidden anyone's reply. But you can tell, like, people have a little symbol by the side of their view count, right under it. There'll be a little bitty symbol, and when you click on it, you could find that. And again, it's archivable. I archived them. I think that shows, again, he's not just spreading false information. He's making sure that the false information is the only findable narrative. He didn't shut down the commentary because commentary drove that. It gives engagement. So he didn't hide all commentary. He didn't turn it off. He selectively hid commentary. 2012, thanks for 5. It would have been better if we sued Bouzy for deception. It'd been a better shot. NYC legal system is a scam, not justice. I'll go with that for sure. What's up, L? Thanks for the 10 months. Hey, Tuck and chat too. Have you heard about Lizzo BS? Yes, I've talked about it a little bit. We need to really get down in the dirt about that. Let me say this though, straight up. Okay, a lot of people. Lizzo has been controversial sometimes because there were a few social stances, and also, of course, with the I'm going to say people body positivity versus unhealth. Let's say it that way. So it's been very controversial. Having said that, there has been no proof added that Lizzo did shit. So I find it to be very nasty. But we'll talk about it. We can talk about that for a minute. So he linked the video with his initial statement describing later tweets in which he debated the meaning of plaintiff's words, and video with Twitter users referred to the video by stating the plaintiff admitted to a felony on camera. And it was actually, like I said, there was a lot more to that. Again, that's backseat driving, or Sandy, thank you for those 5 gifted memberships, by the way. Thank you for that. Appreciate that. I love to watch them go in. Thank you. September 21st, plaintiff through counsel transmitted a letter to defendant demanding defendant cease and desist from defaming plaintiff, and plaintiff delete any defamatory tweets still online. Defendant issued a series of tweets in response to the letter, stated he and Bot Sentinel would not comply with plaintiff's demand and encouraged plaintiff to file a lawsuit. Defendant reiterated his statement that plaintiff admitted he had falsified evidence as a police officer in a video, with a link to the video included in the same tweet. Defendant expressed amusement. You know what I don't understand? See, here's Bouzy's game. He keeps people on the defensive. I don't know why people just don't start pointing out the fact that he's a crypto scammer. I don't know why the people don't spread that everywhere, because it was mentioned in, it's not a statement that you came up with. It's a statement that came up from Wired by his own partner. Falling for the ploy of falling back on your heels and being on the defensive all the time. That actually gives somebody. That's the game. That's what buzzwords and calling people sexist, racist, all of that. It puts you on the defensive. You're like, oh, no. That's not me. No. I'm not that thing. It gives somebody the power over you. Fuck them having power over you. You spit in the like whatever you say, crypto Bouzy. So defendant reiterates his statements. Defendant expressed amusement at plaintiff's lawyer's contention that plaintiff had a spotless record when he was campus peace officer at the City University of New York. It's still more tweets. Defendant attacked plaintiff's character in many ways. He stated that plaintiff was the type that would insult black women so he could fit in with his Caucasian peers, and that he was not comfortable in his own skin. And that he attacked defendant to receive attention because he desperately wants to be relevant. These statements right here, again, he makes it very clear. He attacks a successful black man. He picked them out of anyone else because he wanted to put him in his place. Again, read that statement there. He's the type that would insult black women so he could fit in with his Caucasian peers. That's a nasty piece of shit right there. He's not comfortable in his own skin. He kept calling him, a token. Just all kinds of nasty stuff. And much worse. Defendant Twitter account gained followers, of course, during that time. So procedural history. Plaintiff filed lawsuit October 28, 2022. Superior Court, New Jersey, blah, blah, blah. Complainant asserts that defendant's statements described above constituted defamation per se. First claim, defamation per se. Second claim, false legal tort. Third claim, an intentional interference with a prospective business advantage. Fourth claim. Defendants timely removed the suit to this court on November 4th, 2022, based on a diversity jurisdiction. Defendant subsequently filed an instant motion to dismiss, and the parties have completed briefing. So the legal standard. An adequate complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. This rule requires more than labels and conclusions, and a formulaic recitation of elements of cause of action will not do. Factual allegations must be enough to raise a right to relief above a speculative level. A claim for relief must be plausible, and a complaint will not survive a motion to dismiss if the well-pleaded facts do not permit the court to infer more than the mere possibility of defendant's liability. Again, they give the case there, noting Rule 8 requires a showing rather than a blanket assertion of entitlement to relief. When considering the motion to dismiss give the rule there, a court must accept all factual allegations as true, construe the complaint in the light most favorable to the plaintiff, and determine whether, under any reasonable reading of the complaint, the plaintiff may be entitled to relief. However, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. Determining whether the allegation in a complaint are plausible is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. So discussion, choice of law. At the onset, this court decides which state laws govern substantive issues, in this case, using New Jersey's choice of law rules. New Jersey courts apply the tort laws of the state with, quote unquote, the greatest interest in governing this particular issue, and generally follow the restatement or second conflict of laws, the restatement. So they give, again, a good definition, pursuant to that entitled the multi-state defamation, when a person claims to have been defamed by an aggregate communication, such as a newspaper publication or television broadcast, which is aired in more than one state, court should apply the law of the state where the person was domiciled at the time, if the matter complained of was published in that state. Restatement, of course, they give the conflict of law in a multi-state defamation case. Comment E further explains that the reason for this is that defamation laws are designed to protect a person's interest in his reputation. Thus, a state other than the state of the plaintiff's domicile may be that of most significant relationship if it is the state where the defamatory communication caused plaintiff the greatest injury to reputation. For example, where the plaintiff is better known in this state versus the state of the domicile. Plaintiff is domiciled in New York, and he does not assert that the alleged defamatory statement, which were published to a global audience on Twitter, caused him greater injury in New Jersey than in New York. Plaintiff concedes that the injury was suffered, quote unquote, nationwide, and he does not claim any special connection to New Jersey, while New York is the state of his residence and the place where he has practiced law and worked as a police officer and prosecutor. Thus, New York is the place where plaintiff's reputation would most likely be injured by defamatory statements on Twitter. So New York law governs the substantive issues in the case. Now, false light, third claim. Because New York law applies here, plaintiff's false light tort claim is dismissed with prejudice, since neither a false light claim nor any other common law privacy tort exists in New York. Plaintiff does not dispute this fact and only seeks to bring this claim under New Jersey law. Plaintiff briefly argues that the same underlying facts support a defamation by implication claim under New York law, but he does not assert such a claim in this complaint. In any event, for the reasons explained below, his complaint lacks sufficient facts to state a defamation case. So defamation, first and second claim. New York law. Defamation is the making of a false statement that tends to expose a person to public contempt, hatred, ridicule, or disgrace. Defamatory statements expressed in writing or print are also referred to as libel. Sometimes, I will, for social media, I will call them something else. Like, that's my bad. A claim of libel in New York has 5 elements. Written defamatory statement of fact concerning the plaintiff, the publication to a third party, fault, either negligence or actual malice, depending on the status of the liable party, falsity of the defamation statement, and special damages or per se actionability. Since falsity is none of the libel claim, and since only assertions of fact are capable of being proven false, a defamation or libel action cannot be maintained unless it is premised on the publication or the published assertions of fact. Statements of opinion are not actionable, no matter how offensive. However pernicious, this is the statement here, however pernicious an opinion may seem, we depend for its correction, not on the conscience of judges or juries, but on the competition of other ideas. The only type of opinion that is actionable is one that implies that is based upon facts which justify the opinion, but are unknown or undisclosed to those who are reading it. Right here, like I said, when you read these, remember, okay, think about what I was saying, all right? When you read this, again, adding in hiding statements with the intent, you're going in and presenting this stuff as fact. He edited video to present something as a fact, not an opinion, as a fact. Someone admitted to, they did blah, blah, blah. Then they went out and they made sure on their own, manually, to hide anything that set the record straight. But anyway, the only type of opinion that is implied, that is based on fact or unknown or disclosed to those reading it, that's where we were. Okay, so again, so you're stating that actions of criminality would not be actionable if the facts on which They are fully and accurately set forth, and it is clear that the accusation is merely a personal surmise built upon those facts. Opinion based on disclosed fact are protected First Amendment speech, because when an article discloses the underlying facts, readers can easily judge the facts for themselves. Whether a statement is fact or opinion is a question of law that turns on whether a reasonable reader could consider the statement to be conveying a fact. This analysis depends in large part on the context in which the statement was made. If Brian, again, rather than sifting through a communication for the purpose of isolating and identifying assertions of fact, the court should look at the overall context in which the assertions were made, including the forum, to determine how reasonable reader would apply them. Taking context into account, the New York Court of Appeals has held that statements made at a public hearing were not actionable defamation because reasonable listeners came to the public hearing with expectations that the speaker is airing a layperson's opinion, and because a person who is defamed at a public hearing has the remedy of self-help, that is, the immediate opportunity to air his competing view. Courts applying New York law, mindful of the first opinion, should be reluctant to employ their powers to correct errors uttered in the give and take of live public debate, where there is reason to believe that the give and take itself can adequately or more appropriately remedy the wrong. Where the plaintiff is a public figure, the First Amendment requires that he demonstrate the alleged defamatory statement was made with actual malice, that is, with either the knowledge that it was false or reckless disregard of the truth. An otherwise private individual who is not a household name may be a limited purpose public figure if he has taken an affirmative step to attract public attention. This is something that I talked about before. I learned this very well about limited purpose public figures with Vic Mignogna. It's amazing what fits that. Because again, look at the defamation, the definition to it. He has taken the affirmative step to attract public attention. I mean, what a bar there, right? And basically, what that means, it requires more. We talked about what actual malice, the steps. It's amazing. When people are like, yo, that umbrella guy, why don't you sue X, Y, or Z? Because you have to, when you get into it, we at best are limited purpose public figures. So it's not like just defaming Joe Public. And that's it's crazy in its own way, right? You decide to pick up a microphone and voice your opinion. Well, people can talk a lot of not just shit about you, but they can do some nasty, nasty stuff. So you have a example, or overturning lower courts are ruling that a music producer who purposely sought media attention was not a public figure. The actual malice inquiry is a subjective one, focused on the state of mind of the publisher of the allegedly libelous statement at the time of publication. So your analysis here. Plaintiff is required to show actual malice because he is a limited purpose public figure. He purposefully sought public attention and followers by creating a YouTube and Twitter content on matters of public interest, including analysis of Depp Heard trial and criticisms of Bot Sentinel. Look at how easily you just became that, right? Videos on his YouTube channel, which were created to make the law more accessible to the people, have been viewed more than 27 million times. Again, here's finding individuals who posted political videos on Facebook was limited purpose public figure. Plaintiff's defamation claim fails because he has not sufficiently alleged that defendant made any false statement of fact with knowledge that it was false or with reckless disregard for the truth. Again, I'm not going to hammer. Yeah, I am. Again, hiding shit for the purpose of creating a specific narrative, making sure that that counterpoint that people argue, it can't be seen. It created the end-all narrative. Crucially, the overall context in which the alleged defamation occurred here is Twitter. As both parties are well aware, given that both have engaged in calling out mistruths on the internet, Twitter is a public forum where a reasonable reader will expect to find many more opinions than facts. Reasonable. When I see people talk about reasonable in Twitter, it kind of blows my damn mind, you know? I'm like, we act like, I mean, you have to remember that the standards in a place like Twitter, they are essentially, God, my phone just died. Give me a second. They are essentially, people read headlines. They don't search. You know, we've seen, there's been some very interesting studies that have found more than 80% of people that look at something, they look at, say, a headline. They don't engage and go beyond said headline. They just take the headline as fact. In fact, there was a really interesting study on that, showing people retweeting headlines. And when they did this, what they did is they set up a specific narrative headline, and then beyond that, the article told you that it was fake. It just straight up. It was right from go. It was like, blah, blah, blah. This is, you know, it told people. And less than 20%, less than 2 out of 10 actually looked at the article and caught that. They never opened it beyond the headline. They took the headline as true. So when people talk about reasonable readers, it's like, yeah, okay. Essentially, most people online are absolute morons. But New York courts have consistently protected statements made in online forums as statements of opinion rather than fact. Now, here's noting that the tweet does not give the same impression of truth as a newspaper article. So, you know, it's fascinating that you have, in a lot of ways, even more protection by being some dumbass than if you were a journalist that has quite a few protections by itself. Anyway, moreover, Twitter is a forum where a user in the same setting and with the same audience has the immediate opportunity to air his competing view. That's actually not true at all. See, that's a shit thing, because it assumes that the entire world can find what you say. When you go out and you talk this trash about somebody, typically that immediate statement, it is going to be, if it catches on, that immediate statement is going to be seen by multiples of 10 when you compare. If you look at that, that's what happens, you know, because it takes effort to go and to find out what the other person is actually saying about something. Most people will not engage that far down the rabbit hole. That's just the reality of it. And also, we're talking about algorithm and everything else. So, you know, if somebody ends up getting something to trend, which that happened here, it brought audience, large on it, just because of the algorithmic behavior to the statements that were negative about Nate the lawyer. It didn't bring people. You could look at the numbers, and you could see this in practice. This isn't just, you know, in theory, as it were. This is something you could engage, because when Nate put out his statements trying to rectify this issue, again, multiples of 10. That's the lesser that saw it. But hey, right? It's all the same. It doesn't, again, it pretends that we are all equal. And again, you know, that doesn't count into things like shadow banning or anything else. And it also doesn't count into the fact that, the public mob, the public witch hunt, it is what it is. So moreover, Twitter is a forum where users in the same setting, same audience. This is especially true where the plaintiff was an avid user of the platform with many followers and thus had significantly greater access to channels of effective communication than his peers. Tweets challenging plaintiff's credentials. Several of the defendant's tweets question plaintiff's credentials, including tweets regarding whether the plaintiff was in fact an attorney or former prosecutor. Among these, the only one that is a reasonable reader might view as a statement of fact in defendant's statement that plaintiff was never a prosecutor. However, plaintiff fails to plead facts showing that defendant made this statement with actual malice. So none of the tweets concerning plaintiff's credentials are actionable defamation. Actually, so, he said on the information that he was like, yeah, I knew that he was. I just wanted somebody else to say it. So, that doesn't show that he actually set out to do that, does it? Yeah. What the fuck, man? What's up, Snake Plushkin? Thanks for the 10. So, if I get this definition correct, Bouzy would be considered a limited intelligence public figure. Indeed. That's exactly right. Somebody said boomer judge. And we saw the same type of decision. So there's another case that I was looking at one time where somebody compared being called I'm going to say child enthusiast, playground enthusiasts, those kind of pieces of garbage, compared someone saying that through republication, not a retweet, but republication. That would mean you taking a retweet and adding and making a new post of your own. Compared that to sharing pictures of someone's pets on Facebook. No, kid you not. It was like, wait a minute. That's the stupidest thing I've ever heard. And yet there it was. So defendant's tweets questioning whether his lawyer protected First Amendment speech because a reasonable reader would only view them as opinions, and the facts upon which they were based were disclosed, so a reader could easily judge for the facts for themselves. Yeah, reasonable. Defendant's first statement, inferring that plaintiff was not a real lawyer, was plainly based on the fact that he couldn't find plaintiff in the database where he practices law. And this tweet included a link to the New York court's website. Plaintiff concedes that the name he used isn't the real name, so it's not false for defendant to say that he couldn't locate it. A number of defendant's tweets allude to the fact that plaintiff might not be using his real name, so surely a reasonable explanation is why he did not appear in the attorney database, giving the reader... Again, he said that he fucking already knew it. Oh my God. He already knew it. Plaintiff alleges that the day after posting, defendant, he said, he explained that he had tweeted prior statements, not appearing knowingly and willfully. However, the tweet that purportedly explained this is not so clear. Defendant referencing back to an earlier tweet in which he said there was no history of him practicing and maybe that name isn't the real name, stating that he already had the information. The statement does not demonstrate the plaintiff knew from the outset that plaintiff, in fact, a lawyer under another name. It did. He said he already had his name and shit. He knew this. He was just waiting on somebody else to say it. Oh my God. He very clearly said that. Moreover, it is unclear what information he had, assuming that the information was the plaintiff's real name. Are you kidding me? Well, we're not really sure what information he made. Oh my God. He should have been like, really? I have the exact information of his real name and him practicing law as a lawyer. I mean, it's like, wait, it's 280 characters, man. What are you doing?
Are we going to get a Coke?
You're what?
I like Coke.
You like Cokes, huh?
Yeah. Why's my hand hurting so bad?
Why's your hand hurting? Let me see it. Can I give it a kiss? Mwah. Is it better now?
Still moving.
It's still moving. Yeah, it better move. Fingers should move.
It's still.
Oh, well, here. Let me. Is that better?
No, I need my plug back to play my Switch.
It doesn't look. Oh, you have to play a Switch. Is that what?
Yeah.
Is that what will make your finger feel better?
Mm-hmm.
Okay. Hey, go ask Sissy about where your iPad cord is. Okay. She calls it a Kindle for kids iPad. So go ask her.
I can't.
Go ask her where it is, and she can plug it up for you. Okay. She'll plug it up for you. Love you.
It's already plugged in.
Well, why are you asking me to plug it up if it's already plugged up? What a neck. She believes in the miracle of, a kiss on your finger or something. You know how kids are like that. You're like, mwah. Or I'll be like, here's a kiss. I'll blow it to her. About, mwah, here's one. Rub it on your finger now. She'll rub it on there. She'll be like, it's all better. And she was like, no, it doesn't feel good right now. You know what I need? I need a Switch to play and a Coke. I was like, what? I'm injured. I really need a Coke and a Switch. Oh, Lord. In the same tweet, in which defendant admitted the plaintiff was in fact a cop and became a lawyer in 2016, he added that the plaintiff was never a prosecutor. This tweet included the screenshot of attorney detail report, which a New York court's website dated in 2022 with blocks of text blacked out. A reasonable reader could believe that defendant derived all the stated information about his career from this page, which is not visible to the reader. And thus the defendant's statement, there was never a prosecutor, was a statement of fact or opinion based on that. Of course, this statement was false. However, plaintiff does not allege any facts showing the defendant knew the statement was false at the time it was published, and he made it with reckless disregard for the truth. The complainant demonstrates that the defendant had some regard for the truth, as he deleted older tweets with misstatements, and even in the same tweet containing that, admitted to his prior misstatements. Yeah, damage done. So really what you're telling me is I could go and I could look up that's interesting. So you're telling me, like, for the sake of argument, I could go to, say, an offender registry. I could look up somebody with a somewhat same name and be like, well, I can't prove that it's not that person right there, right? And then later on, after I defame them as a playground enthusiast, I could be like, oh, well, maybe I was wrong, and delete old statements days later. Interesting. So he concedes the falsity of the claims about plaintiff's background and continues accepting these alleged facts are true. They do not establish actual malice. So tweets accusing plaintiff of criminal misconduct. Defendants tweets contending or suggesting that plaintiff committed crimes are also a statement of opinion, so they cannot form a basis of a defamation claim. Defendants' tweets describing him as a grifter, liar, troll, or participating in a smear campaign are clearly opinions in the context in which they were stated. So what's fucked up about this is here's the part that's being left out. He's not just some random dickhead out here. Excuse my words. This irritates me a little bit. Saying this is the guy that runs Bot Sentinel. Bot Sentinel is supposed to have algorithmic proof that you are part of smear campaigns. They go in and they judge you based on this. So he claims to be a specialist in this field. I mean, that's the kicker in that. He's not just some random Joe out here. He claims to be, again, he claims specialty knowledge. He understands that. He gets hired to do it, so he says, I mean, that's amazing. No, just random guy. Defendants' more direct accusations of criminal conduct cannot constitute defamation because they were disclosed the facts upon which they were based. Defendant began the string of tweets about planting evidence with new unearthed videos. It's not a link to the video. See, this is a mistake too. It wasn't a link to the video reference. He posted partial clips. He edited a video himself. He made sure that he took partial portions. He didn't give the entirety of something. He gave a partial statement of fact. He said, this is what it's based on. He himself constructed that narrative. And remember, this shit goes both ways. Like, he can rise to pom-poms and celebrate today, echoing to oblivion. But the reality is, it comes around too. But Subsequent tweet continued the debate of plaintiff words in the video meant make it clear the reasonable reader of his statement accusing plaintiff of criminal conduct were merely a personal surmise built upon what plaintiff said in the video. Similarly, defendant's tweet stating that plaintiff bragged to his YouTube following about illegally obtained defendant's social security number contained a link to a YouTube video. Readers were free to, and apparently many Twitter did, in fact, reach different conclusions. See, nobody linked the fact that he hid those are fucking shit. Other tweets criticizing plaintiff. Defendant's other tweets cited in the complaint, though offensive, are non-actionable opinions because a reasonable reader would not believe them to be conveying facts, especially in a broader context in which they were made. The parties sparring on Twitter. Oh, they were sparring now. So, you wouldn't think they would be fact because, well, even though they're presented in fact, they were going back and forth. what a shitty thing. Anyway, intentional interference, prospective business advantage. Plaintiff fails to dispute that his claim for intentional interference with a prospective business advantage is duplicative of damages claim under New York law in the instant circumstances, merely arguing that New Jersey law allows such claims to proceed together with defamation claim. In any event, he has not pled facts sufficient to support this claim. Plaintiff does not allege that defendant interfered with any specific contract or binding business relationship. So this claim is construed as a claim of interference with non-binding existing or prospective economic relationships. To state a claim based on interference with a non-binding relationship, the plaintiff must generally show that the defendant's conduct amounted to a crime or an independent tort, unless the defendant acted with the sole purpose of inflicting intentional harm on the plaintiff. Plaintiff has not sufficiently alleged the defendant's actions amounted to a crime or tort, and his allegations that defendant's actions were all part of a campaign to cause social media platforms to limit, restrict, or eliminate access, their ability to profit, are insufficient to demonstrate that defendant acted with the sole purpose of inflicting harm on plaintiff. Maybe you should show where he goes to the media and has media. It's amazing. I mean, this is the same asshole that goes to Rolling Stone. Has Rolling Stone, since he couldn't false flag stuff, he was Rolling Stone help false flag YouTube channels, removing them. Oh, yeah, that is exactly the point in doing this. Anyway, the complainant itself alleges that the defendant had other motivations for making false statement. He was offended by the criticism of Heard, Bot Sentinel's reports. He wanted to promote himself and advertise Bot Sentinel. He attracted a broader audience. So, conclusion. For the reasons said above, defendant's motion to dismiss is granted. First, second, and fourth claims are dismissed without prejudice. Third claim is dismissed with prejudice for failure to state a claim. Plaintiff shall have 30 days to file an amended complaint. So, again, motion to dismiss granted here. You see the reason set down. You can file again within 30 days if Nate the lawyer chooses to do so. The kicker to all of this stuff, though, here's the problem. Again, it's flipping. And, these are very expensive coin flips. Look at how much money it costs just to get right here. Look at how much money. Justice is not very just, because it's not just a game of numbers. It's a game of, well, maybe if you get through. Maybe if you get past this point. The problem is, if it would have gone past this, it would have just dragged and ground. And it every time it grinds its gears, as it were, it eats money. It absolutely eats money. But I wanted to go over that. I wanted to make sure that people understood exactly what transpired. And read it over with other folks, because it is something. It is absolutely something to go through. And and to see just the craziness, the insanity. Oh, it's frustrating, that you that in order for you to get anything done, I mean, really, I mean, you have to go well above and beyond. But anyway, I think I included a couple of things. There's some Dan Wooden stuff I wanted to include today, and some stuff with Eve Barlow's craziness. But I think I'm going to call it here. I think that's a good place for it. I think that's enough for a good live stream, And the fact of the matter, again, is while doing this little dance, pretending, hey, man, I won something in that. Yeah, this is a two-way street. And he'll run into the same thing. He will run into exactly the same thing. And one day he's going to run into somebody that will take him, he'll take him all the way down. Because, so far he's been able to play the buzzword game. And it's came out for him to a degree. Like he's had the survivability on places like Twitter, in that forum, in that sphere, debating. But the crowd that he attracts, they always eat their own. It is beyond question. But anyway, I'm going to call it tonight. We'll talk about the other stuff. Maybe tomorrow. We'll see. I'll have some videos tomorrow, too. I got some stuff I got to cover. We had huge storms yesterday. They were rough, so I had videos I wanted to put out today, but I just couldn't get them in. Hey, what's up, Eclipse Warlord? Thanks for the 16 months. Hey there, Tug. Packing for Anime Matsuri. Hope you have a good weekend. Hey, I hope you have fun there. Next year, maybe I'll think about it. This year, myself, I'm going to chill without it. But anyway, all right. Well, I'm going to end here. I appreciate you, folks. We'll see you.